Hello, I'm Attorney Todd Leneve. Welcome to West Virginia Gun Law. This past Monday, April 8th, 2024, Attorney General Merrick Garland signed off on an ATF final rule that redefines who is engaged in the business of selling firearms. I thought we might take a few minutes today to talk about that rule, some of the elements of it, and how it affects you as the everyday person who might choose to sell one of your guns at some point in the future. Stick around. ATF Rule 2022R-17 takes a deep dive into redefining who's a seller, who should be a seller, looks into a number of different definitions that are currently in the Federal Register, and basically expands on those definitions or refines them for the purpose of trying to capture more people within the spectrum of who should be a licensed dealer, and therefore conducting background checks prior to transacting any type of firearms deal. So this 466-page document goes into great depth on a number of these topics and focuses really ultimately on redefining what it means to be engaged in the business of selling firearms. Now, previously, the ATF and the Department of Justice looked at people who were engaged in selling predominantly for the purpose of pursuing a livelihood and earning profit, and said that those types of individuals were clearly dealers who fell under the licensing requirements of the Gun Control Act. Well, under this new rule, instead of looking at somebody doing this for the purpose of a livelihood, the ATF is now saying we're going to limit this to strictly looking at people who sell firearms predominantly to earn a profit. So what's that mean? Well, obviously firearms are appreciable assets, meaning when you buy a gun, as long as you don't beat the tar out of it, you keep it in good condition, it's going to get more valuable as time passes. Therefore, if you were to sell that firearm later on, there's a good chance that you would be able to sell it for more than you purchased it for. And as a result, you've now made a profit. Under this rule, you now would be under closer scrutiny by the ATF and the Department of Justice as potentially being an unlicensed dealer. The final rule expressly recognizes that individuals who purchase firearms for the enhancement of a personal collection or a legitimate hobby are permitted by the GCA to occasionally buy and sell firearms for those purposes, or occasionally resell to a licensee or to a family member for lawful purposes, without the need to obtain a license. So what's interesting about this provision is that they've gone to steps to specifically identify licensees, an FFL or a federal firearms licensee, gun dealer, or family members as people to whom an occasional sale would be okay. Notably, what's not included in that description is other private individuals. Now, this isn't to say that the rule expressly says you can never sell to another person, but the ATF went to steps here to ensure that they included licensees and family members as examples of people to whom a sale might be okay under specific circumstances. They did not include other third parties. But we're also talking here about a personal collection, and we get some further definition here under this rule of what a personal collection is. The Notice of Proposed Rulemaking proposed to define personal collection of firearms, and personal firearms collection as personal firearms that a person accumulates for study, comparison, exhibition, or for a hobby, e.g., non-commercial recreational activities for personal enjoyment, such as hunting or skeet, target, or competition shooting. Notably, the rule states that firearms accumulated primarily for personal protection are not included in the definition of personal collection. So is the rule saying that AR variants, AK variants, whether rifles, pistols, whether in their original calibers or in pistol caliber carbine form, semi-automatic pistols are not part of a personal collection? Is that the point that they're making here? It seems that we're creating a distinction between grandpa's old woodstock deer rifle and a modern rifle, such as an AR-15, that somebody might use to hunt, but because it doesn't fall under this definition, may in fact not be okay because maybe those are considered more exclusively to be for purposes of personal protection. So the ATF, by adding this definition, seems to be creating a further divide between recreational firearms and firearms that are more typically associated with self-defense, and saying, hey, those kinds of guns aren't included as part of a personal collection. So I think that that definition is dangerous in the way that it seems on its face to classify defensive weapons compared to any other type of weapon. The rule also says there is no specific threshold number of firearms purchased or sold that triggers the licensure requirement. ATF intends to further update the guidance once it issues this final rule. This sounds an awful lot like what we seem to hear out of Congress frequently these days. Well, we have to pass the bill to find out what's in it. We have a situation here where the ATF is saying, well, we don't really know how many times you buy or sell something would make you a dealer who's acting in an unlicensed manner. So we need to pass the rule first, and then we'll provide more guidance on that once we have a better idea ourselves. Unfortunately, this is just another case of our government failing us and basically putting us in a position where we have to be able to interpret the rule and judge our own actions, make our own decisions, and decide, boy, am I doing this the right way, or am I doing something that might step afoul of the rule? I don't know. And it seems that the ATF doesn't either. But they can always come in with 20/20 hindsight and set a standard and then say, sorry, you violated the rule because you engaged in X number of transactions, and we only intended to allow Y number of transactions before you would be considered an unlicensed dealer. So there is a real minefield here in terms of them imposing this rule, but not providing guidance that tells you how you can remain in compliance. I think that the big takeaway from this is to understand that any transaction on a private basis is now potentially subject to scrutiny under this rule. And we have to be ultra cautious in deciding how we choose to sell a firearm, to whom we choose to sell a firearm, and how frequently we choose to do so. How about situations where maybe you're involved in an organization that decides to have a gun raffle to support a cause, maybe a local community member who has a particular financial need, whether it be a family that lost a home in a fire or an individual who's got medical bills that have exceeded their ability to cover them. And so we see community organizations often come together in situations like that and sell a rifle, a hunting rifle, an AR-15, a pistol, whatever the case may be, with the idea of creating proceeds, profit, that they can then turn around and donate to this person or family in need. That's good community involvement, but not under this rule. Under this rule, if you engage in raffles more than once perhaps, now suddenly your organization has to become a licensed federal firearms licensee. You've got to be a dealer because you chose to be helpful with the broad reach that your organization has and bring money in to help people in need. That's absolutely a ludicrous situation but it's one that the rule talks about, saying that raffles are the kind of things that could in fact lead to an organization being required to obtain a license. So we have to take a look at what's going on here. We have to understand that this rule is very broad, that it has things that even the ATF doesn't seem capable of defining at this stage. And they're saying that we've got to make sure that it becomes a rule, and then we can begin digging into it and offering guidance on how you can avoid getting sentenced to prison and fined into the tens of thousands of dollars for your criminal activities. Now, it hasn't taken effect yet. It won't take effect until 30 days have passed from the date that it's entered in the Federal Register. As of today, I am not aware that it has been entered into the Federal Register, but that is very likely coming soon, and I would anticipate the ATF essentially saying this rule will be effective in early May, sometime between perhaps the 8th and the 15th of May. This rule likely will go into effect. Now, it's also quite likely that we're going to see a number of the grassroots Second Amendment organizations getting out and filing lawsuits to try to prevent this rule from going into effect. So for that reason, I encourage you, please check out the list below of the most active 2A organizations who get involved in litigation in the federal courts around this country, and consider supporting one or more of those with your money so that you can help them in their fight to further protect our Second Amendment freedom. This is a really complex issue, and this video really just kind of scratches the surface by going after the highlights. And I want to urge you to please understand, it's important that if you decide to sell a firearm, that you do so in a manner that would not cause you to come onto the radar scope of the ATF or the Department of Justice. There would be huge problems potentially coming down the pike for you if you don't follow the rules and make sure that you're doing this in a manner that can't be questioned. If you have questions about any of this, please get in touch with us. Our contact information is available through the websites that are linked in the description below. And again, I would encourage you, join one of those Second Amendment grassroots organizations also listed in the description below, and support their effort to protect us. I appreciate you spending the time with me today. I look forward to seeing you in the next video. And until then, take care and be safe.